So chapter 12 is a relatively short chapter. It's closing or closing statements. It basically introduces what we're going to do for the remainder of our time when we get to our closing statements. But there are 3-4 terms in chapter 12 that are going to be very important to you passing your exam. And so I'll point those out. The first one, which you may or may not see, is the word abstract. And abstract is not a term that's very familiar to us in this state because we close at a title company. But if you go to Minnesota, they would use an abstract. So we don't use an abstract. You may also have heard the term escrow. There are states where they close an escrow, and we don't do that as well. We close at a title company. And so the Hollywood version of real estate is not as applicable to South Dakota as maybe other states. So all of our closing takes place at the title company. In fact, when we get into the settlement statements that we're going to work on later, we don't even do those. The title company does all the settlement statements for us. So an abstract is a condensed version of the history of title. It goes all the way back to when that land was first given from the government to the person through the use of the land patent. It gives the chain of title, so we have listed in there all the owners, again, from the very beginning of time, who own that property. It doesn't guarantee good title. It's simply a certificate of title. It's usually done by an attorney, and it's their opinion as far as the accuracy of who are the owners or who are the people out there holding a stick or piece of interest in that property. Title insurance is really what's going to protect you in case there is some people out there, for instance, holding a stick, or there is some clouds in the title or some defects in the title. It's going to protect you so that you don't have to bear the brunt of it. It does guarantee good title, and it basically, again, indemnifies you against matters which have already occurred. If there's something that happens after your ownership that as a result of your actions, then you're going to be responsible to take care of that and clean that up. So some examples of that would be some unrecorded liens or judgments, some forged deeds or illegal acts or false claims that are out there that happened prior to you taking on this ownership of the house. Some of the obstacles to clear title when it comes to closing would be unrecorded liens, again, unpaid taxes. The seller's going to have to get all those taxes caught up because in South Dakota, we pay taxes in arrears. So if I'm paying my tax, or I'm writing out a check to the county to pay for my taxes in April, I'm not paying for April 2015, I'm paying for April 2014 if we're in the year 2015. It also, if we don't have an exact location of the boundary lines, of course a survey is going to give us those. But just things that would come up, zoning and any other issues or interests or claims that the public may have, those things are going to be taken care of or should come to the attention of the person that's doing that title search. The owner's policy for title insurance is a one-time fee. It's charged to the buyer, but typically it's going to be split, or the cost of it's going to be split between the buyer and seller, and it runs indefinitely. So the coverage will run indefinitely, and it's not transferable. So let's say we buy a house in 1999, and the title insurance costs $500, and that's going to be split 50-50. So 250 of it is going to be paid by the buyer that's buying the house, and then 250 of it is going to be paid by the seller. And so in 2009, 10 years later, the house is sold again, and title insurance now is $675. So now we're going to split this 50-50 as well. And the buyer, who was the buyer 99, is now the seller in 2009. And then we have our new buyer here. So 675 is split 50-50, so it's 337.50. 337.50. And so that's typically how a transaction will look like in this state. The buyer and seller split at 50-50. So it's nice for the buyer at this point on the front end when they're buying up here because they only had to pay half. Now when they go to sell, they're going to have to pay half of the policy. So it kind of all balances itself out. And this title,
Is it a law?
it's not a law. It's agreed upon.
They call it a closing cost?
Nope, this is the title insurance.
But aren't they included?
It's separate. Our closing costs or our closing service fees is what's charged by the title company, and that's typically split 50-50 as well. There's a difference. Closing costs and closing service fees. So there is a distinct difference between these two. The closing service fees is what's charged by the closing company, or we could say the title company. So ABC Abstract or First Dakota Title, wherever you're closing at, they charge a fee to close there. They have to do all the paperwork. They gotta, they have a person hired, your title officer or closing officers there. There's hourly wages. There's the money to keep the lights on. There's rent. There's all that. And so they charge you a fee. And that's usually, we're looking at maybe $500 to $700. And that is split 50-50 between buyer and seller. Just like title insurance is split 50-50. And those two are separate lines on our purchase agreement. And typically those are always split 50-50 between buyer and seller. Closing costs, these are what the lender charges. To the buyer to do the loan. So, or to expand that out, it's not just the fees the lender charges, but everything the lender is requiring the buyer to do to proceed with the purchase of the house. Because the buyer chose to go to the bank and get financing, the bank's going to have a say in what happens. They're going to require things like a survey, an appraisal will be required. The bank needs to, it needs to be verified or justified to the bank that there's enough collateral in this house so the bank can do the loan. You're going to have fees from the bank for underwriting the loan, processing, an origination fee. You're going to have other fees like that, fees that the bank is charging. So it's going to be requirements that the lender has or their fees and or their fees. That's going to be the closing costs. As you can see here, we're looking at, maybe $250 to $350, and then another $250 here. So a few $100. This is usually a few thousand. We're going to have an origination fee, which a lot of times is 1% of the loan amount. So if it's a $250,000 house, that's $2,500 right there, just for the origination fee. We have anywhere from $90 to $150 for the survey, $350 to $450 for an appraisal, and so these things will add up pretty quickly, and they're going to be in the thousands. And so you may have a buyer that needs the seller to help them with their closing costs, and that's what they're talking about. So they may ask the seller to contribute $3,000 or to contribute $1,000 for their closing costs. They're different, but they're always charged on a percent of the loan. So a discount point and an origination fee are two separate things. An origination fee is usually how the lender gets paid, and a discount point is pretty much there to buy down the interest. It's a form of a prepaid interest is what the discount point is. But they're going to be a percent of the loan amount. So they are the same in that regard. So the lender may charge one discount point, which would be 1%. Two discount points would be 2%. Three discount points would be 3%. Origination fee would be 1% of the loan amount, unless they state otherwise. When we look at the settlement statements later, they may say that the origination fee is 0.75, and they'll tell you in the math scenario, but it's going to be based on the loan amount. And I always want to stress that because it's very typical when we get into these exercises that we take it off the sales price, and the sales price and the loan amount are usually different because the buyer has to come up with some down payment, and so that loan amount is going to be lower than the sales price. So once the title insurance is purchased, this is going to run until the buyer is here in 2009 selling the house again. So for that entire decade, this house has been covered by title insurance. If the buyer doesn't decide to sell until 2059, then it's been on there for all those years. It runs indefinitely until the buyer sells. And once the buyer sells, then the new buyer is going to have to put their own title insurance policy on the house. They can't transfer it from one owner to the other. The mortgagee's policy, which is the lender, we learned earlier that as a buyer, you give a mortgage to the bank, and the bank receives it, so the buyer or the borrower is the mortgagor, the bank is the mortgagee. So the mortgagee's policy or the bank's policy covers only the loan amount. And then lastly, we have this Torrens system. And Sir Robert Torrens founded this Torrens system, hence the name Torrens. And it was one of the earliest ways in which we were able to, in the best way possible, deliver clean title or clear title to a new owner. Number one, it requires all deeds to be registered with the county in which that property is located. So we'd have the recordation of those deeds, and that would authenticate legal title. The next thing that would happen with this Torrens system, or combined with it, is that when it came time for closing, prior to that, a notice was put or published in the paper that we were going to be selling the property on 123 North Main Avenue on such and such date. Another thing that would happen with this Torrens system is that a copy of that newspaper article was mailed to everybody that had an interest at one point. Everybody out there that they still had a mailing address for, that they had claimed to have an interest in the property or a stick, they all received a copy of that paper or that article, so that everybody out there knew that such and such house, 123 North Main Avenue, was going to be sold on such and such date. And so on the sale date, on the date of closing, they would have a public hearing and transfer that property from the current owner to the new owner. They would have a portion, kind of like at a wedding, where they say, if anybody objects, speak now or forever hold your peace. So they'd give opportunity for anybody out there that still had a claim on the property to say, I have this unpaid bill, or I still have an interest in the property. And so they'd give them that opportunity to speak up. If they didn't have any objections, they were passing then title to the new owner. So everybody else had sufficient notification that, hey, if you have a claim, you need to be here by such and such date. And that's really it with the Torrens system as far as what you're going to need to know for the exam. Now I realize there probably is more in-depth study that we could do with the Torrens system, but those 3-4 items from Chapter 12 are going to be primarily what you'll need to know for the exam. So we talked about abstract, title insurance, and then this Torrens system.